Hello guys, and welcome to another episode of our civil litigation mock trial course by the DECO Daniel School of Law. And on today's episode, we are talking about the draft of motion on notice challenging the jurisdiction of the court. Motion on notice challenging the jurisdiction of the court. And this is an offshoot of our last class where we talked about the notice of preliminary objection challenging the jurisdiction of the court. Of course, we discussed the drafts, right? Because this is our draft sessions. So we discussed the draft for that class. And in this class, we are discussing the draft for motion on notice challenging the jurisdiction of the court. I emphasized in our last class that there are three major ways to challenge the jurisdiction of the court. It's either you do so orally by making an oral application, or by filing a notice of preliminary objection. And I told you that you use a notice of preliminary objection when what you are doing is basically on law. What you are arguing is on law. You are not arguing on fact. You are going to look at the statement of claim of the claimant, and you can see that this whole matter is on admiralty. Admiralty is not within the jurisdiction of this court. So you file a preliminary objection, right? Challenging the jurisdiction of the court to hear it. You don't have affidavit because there are no facts in contention, right? So what you have is a notice of preliminary objection and a written address. You don't have affidavit when you are filing your notice. However, the third way, which is by a motion on notice, which is what we are learning in class today. Not only are you supposed to file your motion paper, you are supposed to file your affidavit. Why? Because facts are contentious as regards the subject matter where this case falls under, and whether or not that subject matter is now within the jurisdiction of the court. So if facts are contentious, we use a motion on notice supported by an affidavit deposing to the facts, right, and a written address. Do you understand that? So what we are here to learn today is now how to draft that motion on notice challenging the jurisdiction of the court. The motion on notice challenging the jurisdiction of the court. So now the first thing that we talk about is the heading of the court. In the High Court of Lagos, in the Lagos Judicial Division holding at Lagos. You need to know how to properly draft this heading, right? And I told you that if you want to learn more about the jurisdiction, what court is supposed to have jurisdiction, and under what court you are supposed to go and have this your heading, you have to watch our class on Module 2, that is Civil Jurisdiction of Courts, right? Now, after that, we have suit number. Right? Suit number is non-negotiable for law school and even for practice and even for our course in context, right? You need to have your suit number, right? After that, we have what? We have between. Now, we have between, then we don't have our parties stipulated. Right? If you want to know how to properly draft the parties clause, who is the necessary party, the desirable party, who are those that you are supposed to add, proper parties, right? How you are supposed to properly draft, if it's a business name, if it's a company, if it's a representative action, if it's third party, all these things has been taught in our class on parties to a civil suit, which is our module 3. Our module 3 is on parties to a civil suit. We've taught all these things. Now, I further have taught you that when it now has to do with the designation of the parties, we have claimant and we have defendant, right? Claimant and defendant. But because this is an application, we also need to have applicant and respondent in the designation of each of these parties. right? We need to have applicant and respondent. The person bringing the application is the applicant, while the other party is the respondent. I gave you further and detailed explanation of this in our Module 8, interlocutory applications. When I taught interlocutory application under Module 8, I gave further and detailed explanation of this. But as we can see in this class, which is the first thing that I want to point out that distinguishes a notice of preliminary objection from a motion or notice challenging the jurisdiction of the court. The first thing that I want us to see is that after the defendant applicant, do you see /objector there? There is no objector. In a motion or notice, there is no objector. But in a notice of preliminary objection, there should be in your draft for law school. Can you see one of the first differences? You can see heading of the court, there's basically no difference. To suit number, no difference. Parties, no difference. Right? It's basically claimant/respondent, then defendant/applicant, but there's one more difference. For a motion on notice, applicant/objector. But for a motion on notice, is defendant/applicant. But when we are talking about notice of preliminary objection, it's just a defendant/applicant/objector. So we have three things for notice of preliminary objection. We have two things for, motion on notice challenging the jurisdiction of the court. Then after that, we have the heading, which is our second difference. The heading of a notice of preliminary objection says notice of preliminary objection, while the heading of a motion on notice challenging the jurisdiction of the court says motion on notice. Can you see that? Those are the two basic differences that we've had so far. Now, we take another step further. Broad pursuant to. When I was teaching you the broad pursuant to of notice of preliminary objection, I said broad pursuant to, number one, the section of the Constitution or any other law that has the jurisdiction of that court to hear the matter, not the one of this court, but the one of that court to hear the matter. That's number one. Then order 43, number two. Then under the hearing jurisdiction of this court, those three things. In this case now, what do we have? We have order 43 and under the hearing jurisdiction of this court. Now, it is possible for you to still bring it pursuant to section 251. Nothing stops you. Even when we are talking about motion on notice, nothing stops you. You can bring it under section 251. You can bring it under any of the orders if an order permits. Right? But since there is no order that talks about jurisdiction per se, that is why we are bringing it under order 43. Because for motion on notice and motion ex parte, you usually bring it pursuant to the order of the rules of court. Right? You bring it pursuant to the orders of the rules of court. Notice of preliminary objection, you can bring it pursuant to any other rule and even the Constitution. But motion on notice, motion ex parte is usually brought pursuant to orders of the rule of court, strictly speaking. But I don't think you'll be penalized if you bring it brought pursuant to section 251 of the Constitution and section 43. If it is relevant, that's if section 251 is relevant to the question that you are told to answer, I don't think that you'll be penalized for it. But to be on the safe part, just say order 43, which is the general order for all application, as I have taught you in my module 8 class, right? The general order for all application, order 43, and under the inherent jurisdiction of the court. Do you understand that? Now, we then go further. You know, when we're drafting a notice of preliminary objection, the first paragraph, we said, take notice that at the hearing of these suits, right, the defendant applicant intends to challenge the competence of these suits and will be heard praying this court for an order striking out this whole case. These are the three things that we asked for. But in this case, it is not couched in that manner. How do we couch it? We couch it the way normal motions are couched. Take notice that this honorable court will be moved on the dash day of dash 20 dash at the hour of 9 o'clock in the forenoon or so soon thereafter as counsel on behalf of the claimant applicant or the defendant applicant, as the cases may be heard, praying this honorable court for the following reliefs or for the following orders. Do you understand that? Please and please, my dear brothers and sisters and my dear learned colleagues or learning colleagues, as the case is, please take note that you are supposed to cram the notice of preliminary objection, that take notice part, right? The one for preliminary objection, and you are also supposed to do the same for the one of notice. You are going to have the one of notice more frequently used, right? Because you are going to draft a lot of motion of notice and motion ex parte in your exam. That one is non-negotiable. But the one for preliminary objection, it comes out in exam, but might not be every year. But that year that it comes out, you are supposed to jubilate and say, yes, I've learned it. So learn your take notice. Take notice for preliminary objection is take notice that at the hearing of this suit or action, as the case is, the defendant intends to challenge the competence of this suit and will be heard praying this honorable court for an order striking out the suit. So you can see, please and please, I am begging you, learn these things. Now, we take it a step further. We've learned our take notice. We now look at the order. We are asking for number 1, an order of this honorable court dismissing this suit as same is statute barred, right? And then, and for such further orders, that's the omnibus order, and for such further orders as the court may deem fit in the circumstance. Now, I've already taught you what is the omnibus order and when do we use omnibus order, when and what it is about. I taught it in our interlocutory applications module 8. So you need to learn that. And for such further orders or orders as the court may deem fit to make in the circumstance, I taught it in module 8. I cannot be rehashing and reteaching everything every single time I come across it. It's going to be madness, right? I would never end. So I taught that in module 8. So learn that. But the first order is saying that an order of this court dismissing the suit as same is statute barred. Now, this order can change depending on the question that you are giving in exam. So why is it that you are asking for the court to dismiss the suit? Now you can see that we are saying that it is statute barred, right? Because it is statute barred, it is likely to be contentious. So you don't come by a PO, that's the notice of preliminary objection, for something like statute barred. Contract is meant to be 6 years before it is statute barred. You are going to have to show the court facts that this is where the breach of contract arose, right? And this is the time that the writ was issued. My lord, between the time that the writ of contract arose and the time that the writ was issued, it was 8 years, which means that it has elapsed. That the 6 years has elapsed. Do you see what I'm talking about? But this is a question of facts as to whether or not the 6 years has elapsed, which is not a question of law. So you now have to show in your affidavit that, oh, these are the facts in this case, and then argue those facts in your written address that, my lord, this matter is statute barred. You are challenging the competence of the court because the matter is statute barred. And then you put it like that. In exam, there could be other reasons why they will tell you to challenge the jurisdiction of the court and then draft the appropriate process in that regard. If they ask you that question, you need to ask yourself, is this a contentious thing? If it is contentious, you will draft a motion on notice. If it is on point of law, the argument as to the competence of the court is on point of law, then you draft a notice of preliminary objection. Do you understand? So an order, so, and then for such further orders. Now, you find this take further notice for motion on notice. You find it only when you are challenging the jurisdiction of the court. In any other motion, you don't use take further notice, especially in your exam. You only use it when you are challenging the jurisdiction of the court. Even in practice, they don't use take further notice for motion on notice. I think I've seen it once. I think when I saw it, I was like, who be this counsel where they take further notice and don't be saying they challenge the jurisdiction? It is only when you are challenging the jurisdiction that you now say, take further notice that the grounds upon which its application is predicated upon or take further notice that the grounds upon which this application is brought are, that predicated upon is Oyinbo. You can use your own grammar. Do you understand? Then you now say, A, that the suit is caught up by statute of limitation. B, that this honorable court lacks the jurisdiction to entertain the suit. Right? So you have done your take notice. We have take notice for motion on notice. We have take notice for preliminary objection. We have take further notice for preliminary objection. We have take further notice for motion on notice, both of which are challenging the jurisdiction of the court. Take further notice is only for the grounds upon which you are bringing this application. You state it in the take further notice. The grounds. You state the grounds in the take further notice. While your take notice is that you are telling the court, this is what I want. In the case of PO, my lord, take notice that in the hearing of this suit, the defendant applicant intends to challenge the jurisdiction or the competence of this suit and will be praying this court for an order striking out. That is what I want. So that is what you say. Take notice that this is what I want, my lord. While in the case of a motion on notice, my lord, take notice that this honorable court will be moved on the dash day of dash 20 dash at the hour of 9 o'clock in the forenoon or so soon thereafter, as counsel for the claimant applicant to be heard praying this honorable court for the following reliefs. Number 1, an order of this honorable court dismissing this action as same is statute barred. That is what I want. So your take notice is you telling the court, this is what I want. Then your take further notice is you telling the court, this is the grounds upon which I am telling you that I want this. Do you understand the differences? Right? So there is a difference in the way you catch your take notice for PO, that's your notice of preliminary objection, and there is a difference between the way you draft your take notice for motion on notice. Both of them are different. Please take note of that. And then your take further notice can be the same because it's grounds that you are bringing, the grounds upon which it is brought. So you also notice that there is no omnibus clause for PO, but you have omnibus clause for motion on notice. And for such further orders or orders as this honorable court may deem fit in the circumstance. That is the body. Right? So we have the same thing. Just a brief rundown before we end this class. The heading of the court, please, for motion on notice, challenging the jurisdiction, and notice of preliminary objection, they are basically the same thing. Learn your jurisdiction class to know where you bring the matter. For your suit number, same thing, right? For your parties, they are same thing, right? Learn your parties to a civil action. That is module 3, right? For you to know how to couch it properly. But there is one significant difference. While we have claimant/respondent for the both of them, for the defendant, it is not the same. For motion on notice, we have defendant/applicant. But for notice of preliminary objection, we have defendant/applicant/objector. That is not the same. Then we now go to the heading. One is notice of preliminary objection. The other is motion on notice. Then we now go to broad post 1-2. One brings under the section of the Constitution or any other law that gives the other court jurisdiction. And order 43, the general order that talks about application and the mode you come by. And also under the inherent jurisdiction of the court. That is the notice of preliminary objection. While the one for motion on notice most times only talks about Order 43 and under the inherent jurisdiction of the court. Please take note of that. Then we have the way we talk about our take notice. We have take notice, we have take further notice. So how do we couch our take notice for PO, and how do we couch our take notice for MON? That is motion on notice. Please take notice of that. How do we couch our take further notice for PO, and how do we couch our take further notice for MON, motion on notice? Please take notice of that, and note that you only talk about this take further notice, please, when we are talking about motion on notice for challenging the jurisdiction of the court. It is usually not drafted for motion on notice, only when you are challenging the jurisdiction of the court. And then after that, we now talk about dated this dash day of dash 2020 dash, right? And then because it's motion on notice, there is going to be a part for the applicant to sign, as in this case, I, who is the lawyer for the applicant. We have Dear Kolola Daniels Esquire. Then you have Dear Col Daniels and Partners. So it's supposed to be the name of the lawyer, the law firm, who he represents, the address, the email, and the phone number. Those things. The name of the lawyer, number one. The law firm of the lawyer, who you represent, the address, the email, and the phone number. And then for service on or on notice to, same thing. Then you write the name of the other counsel, right? The law firm of the other counsel, the designation of the other counsel, claimant, who you represent, claimant respondent, the address, the email, and the phone number. Follow the same sequence. So you follow the same sequence for the both of them. The name, the law firm, who he represents, the address, the email, and the phone number. And with that, we've done justice to our class for today. I hope that you've had a very wonderful class. We are going to go into other modules and subsequently as well into other draft classes. I will see you in our next class. Please have a very wonderful day.